Good afternoon. Thanks for your presence. We begin preparations for the fourth conference on predictive justice with a speech from the judge. Well, I'll give the floor to Professor Casale for the details.
Thanks, Professor Viola. Welcome, everybody, to this preview and offline session of the fourth conference of predictive justice. We will meet in this session our distinguished speaker, a Spanish magistrate, deeply passionate about digital law and various aspects of technology law, including predictive justice, cybersecurity, and artificial intelligence. Currently, he is pursuing a PhD in law at the University of Granada, which focus is on algorithmic techno-censorship and freedom of expression. Mr. Gutierrez also served as a UNESCO consultant for the Global Toolkit AI and Rule of Law, and it is a co-director of prominent courses and master programs on digital law and business tech. Please join me to virtually welcome Magistrate Alfonso Peralta Gutierrez.
Good afternoon from Spain. I'm Alfonso Peralta, magistrate of the First Instance and Criminal Investigation Court, number 2 of Guadix, Granada, in Spain. First of all, it's a completely honor and a pleasure to participate in this fourth International Congress on Predictive Justice of the Scuola di Diritto Avanzato. And I must apologize. I'm very sorry not to be remotely and not to be face to face, but I'm going to travel and to travel at this time, so it's impossible to me to connect remotely. So first of all, I must thank to Luigi Viola and Pierluigi Casale to think about me, to invite me to this reputed Congress, and to Gerald Garcia to introduce me to the organization. Well, as you know, I'm an interested judge in AI. I have been working with the Spanish Judiciary Council together with University of Granada in AI and law with the continuous program training, and with an eponymous book. I'm the co-director of the master's degree of digital law, privacy and business tech at EDI, or I'm also the sole Spanish consultant at the Global Toolkit of UNESCO of AI and law. And today I'm going to talk about AI in judicial function, risk and benefits. Well, first of all, to congratulate the organization about the topic. It's true that AI is in a hype, it's booming, and it's very important also the AI literacy, not also understanding the AI systems, the opportunities, risk, the harm that it can cause, but also promoting its democratic control. The first 21st century jurist is not only the one who knows digital law, and we are in Europe in a tsunami of digital law in the Europe strategy, but also the one who knows how to take advantage of and successfully apply digital tools for obtain greater productivity and efficiency. These are the book and the global toolkit that I have participated. First of all, if we ask to ChatGPT of OpenAI, is it going to substitute ChatGPT judges? And the truth is that this LLM model of OpenAI answer us that they are not capable of making legal judgments or understanding the nuances of the law in the same way that human judges can. While AI and technology have been used in legal research, document review, and other supportive tasks, but they are not a substitute for the human judgment and expertise that judges provide in courtrooms and legal proceedings. So if we ask also another website, will robot take my job? They answer us that they are only 21% of risks level of automation risk in the profession of judges and magistrates. Everybody knows the advantages and the problems about AI: less bureaucracy, more agility, less cost, less mechanical work, even less litigiousness, but also a lot of ethical and moral dilemmas: the tyranny of the algorithm, threat to judicial independence, biases, overestimation system, lack of motivation, excessive mechanization. And we can find the 5 fundamental principles of AI in judicial systems under environment of the CEPEG, of the European Ethical Charter of the European Commission for the Efficiency of Justice: respect for human rights, data quality and security, transparency, impartiality and justice, and user empowerment of responsible AI use. We are going to talk about that in this presentation. These are maybe the problems about AI: accuracy and sometimes the less of accuracy, do not harm, make a beneficial AI, robustness, bias, lack of context, overestimation, or black box. So sometimes we have seen in the news this title: why are so many organizations banning ChatGPT? We can see the privacy policy. And in the privacy policy of ChatGPT, one of the main worries in the judicial procedures is the confidentiality. And they tell us that when we use their services, when we put an input, when we write an input, or we upload a document, they collect the personal information in the entry, in the file, or in the feedback. For how long? Well, for the long that they need, and in certain circumstances they may provide this personal data to third parties without prior notice. So in Italia, the Italian Garante, the data protection authority, required ChatGPT to change the legal basis of the processing for users of personal data for algorithm training purposes, removing any reference to the contract and assuming the legal basis as the processing consent or legitimate interest. Why? Because one of the main principles in data protection is data minimization, and sometimes these LLM systems, they have done web scraping similar than bottom trolling. The data is accessible to the public and they have used it, but this doesn't mean that data protection regulations don't apply, because they are processing personal data. So there is not an automatic or general interest in use this data. They are under the data protection regulation, and we must analyze if web scraping is a proportional medium. Does it comply with the principle of data minimization? Is adequate? Is relevant? Is limited data as necessary? Also, we don't know the database of ChatGPT, of OpenAI, to train their LLM. We don't have transparency about that. And it's very important, this principle, to the judicial function when we must motivate our judicial decisions. So we need an AI in a secure, traceable, technically sound, reliable, ethical, and legally binding manner, and being subject of a control and supervision independent. Also, in the GDPR, in the General Data Protection Regulation, the Article 22, we have the principle of automated individual decision making, the regulation. So personal data also shall be collected for specified, explicit, and legitimate purposes, and not further. So if you use data of the parties or of the litigants, and we introduce it in ChatGPT, have we informed the litigants or the parties about that? They have some rights about automated individual decision making. Is that ChatGPT automated decision making? Is this concept valid, free, or express? Do the parties have a rational expectation that their procedural data will be transferred to OpenAI or subject to automated decision making? Also, the quality about this LLM is a good quality, because we have seen that is a crawling, is accumulation of data, web scraping, and sometimes the erroneous data, the multiplication of biases could be inherent without parameters of relevance, of reliability, or robustness. So a lot of poor data, a lot of missing data, or selective samplings, or biases and discrimination in this system could also discriminate people. And we have seen that, and they warn us when we enter in the ChatGPT. They warn about there is a clause about they may occasionally generate incorrect information, produce harmful instruction, or biased consent, and they have limited knowledge. We have seen that in some judicial decisions. For example, in Cartagena of Colombia, a judge that used this tool, and the answer doesn't know case law, and when asked the case law, invaded it, and it quote incorrect legal sources. Or, for example, a lawyer who used ChatGPT in court and said fake cases, or a judge who orders lawyers to sign an AI pledge warning chatbots. Also, we should ask if this could be infringement of deontological and ethical or professional rules. This is the pledge of the US judge. There was also a scandal in Bolivia about a judgment made by ChatGPT against 3 journalists, but we must remember that AI or the LLM, they are not the bad, they are a tools, they are an instrument. So LLM models, they are large language models, they are models of language, they are not models of knowledge. And don't ask Gen AI something that you don't know the answer. These are two sentences of one of the most famous and most experts of AI in Spain, David Hurtado. Also, there are a lot of procedures, a lot of suits to the LLM models and the big technological companies of infringements of intellectual property in different aspects. The most famous maybe is the New York Times suit. And sometimes I say that without an AI literacy and with some cautions and with some training. It's like give a Lamborghini to a novel driver or to a driver without license, that it could crash. About the AI Act, and I'm finishing, we know that there is a risk system, and in the high risk system is the administration of justice and the AI to assist a judicial authority. So in this case, we must be very careful with sensitive data. We need mixed and multidisciplinary teams to be able to draw this system to judges, prosecutors, lawyers, researchers, professors, to make a balance between intellectual property and the need of transparency in the judicial function, with impartiality, fairness, and intellectual integrity. And also, in every case, we must assure that the judicial decisions must be under supervision. So we must know the necessities of the judicial career, the judicial power, project the AI solution or the digital or the automation solution, test, implant, and control, because we must think carefully and decide what to automate. Not everything automated is better. It can be better or it can be worse. And I recommend to start with simple tasks and then as a second generation. The AI system in justice is a high risk, so it needs risk assessment, conformity assessment, fundamental rights assessment, and a compliance system with this risk mapping documentation to prove the efficiency, the robustness, the transparency, the explicability, the measures to risk reduction, or an ongoing monitoring in a process, an ongoing process, not finishing. Maybe one of the solutions to the judicial function in LLM or in Gen AI is to use this RAG, or retrieval augmenting generation models. It's also called versus large language models, the small language models, or in even other models that are as federated learning. And we use with the large language model a small language model with these databases, legal databases or judicial databases, more specific, best quality data, and with all the principles we have been talking. And at least, for example, there are a lot of uses of legal tech, but in Spain, one of that is the pseudonymization of CENDOG, of our Spanish Judiciary Documentary Center. And I would like to finish highlighting the human supervision, about the need of motivation, of individualization of the judicial decisions, the transparency use of system of AI control, and use of your own data, and own data must be more relevant, reliable, robust, and overall legal and legitimate, and the possibility that the judge can depart from the automatic proposal. And I don't like to speak about the robot judges, because the judges, we do a lot of tasks, a lot of skills to listen, to talk, to deliberate, to prepare, to write, to decide. So we are not only a robot that make an only and simple task. So these are the conclusions. The need for AI literacy and digital training. No robot judges. AI is a tool. There are a lot of advantages, but also a lot of risk. we must highlight the human supervision and to project and to think carefully about the automatization and digitalization of justice. And there are some ethical and compliance and regulatory obligations to justice in AI. Thank you very much. And um, I hope that the Congress continues with very successfully and very interesting. Thank you very much.
So join me to thank you, Judge Alfonso Peralta Gutierrez, for this warm-up intervention for our conference. We will invite you to join us on Friday, the 23rd of February at 2 p.m. CET, where the live conference will start. Hope we gave you, with this talk, a bit of flavor of what you will get. Thank you very much.
Bye.